That's pretty rare, but you're talking about stress, right? What is more stressful? Not knowing where stuff is supposed to go as a family member, not knowing the things they had, nothing's in place.
I gotta get myself a little more faith, a little more love.
I'm your host, Christa Bigler, and I'm going to guess we have at least one thing in common, that we're both in pursuit of a less stressed life. On this show, I'll be interviewing experts and sharing clinical pearls from my years of practice to support high-performing, health-savvy women in pursuit of abundance and a less stressed life. One of my beliefs is that we always have options for getting the results we want, so let's see what's out there together.
Just keep breaking. I gotta get myself a little more faith, a little more love.
All right, today on The Less Stressed Life, I have Ali Goff. And before I do her intro, a week or two or something ago, I asked on Instagram about trust and wills. And one of my colleagues and friends reached out and said, I'm so glad you're talking about this. And then went into an entire horror story about her family history of trust and wills and topics. And I personally think all the things that fit under the less stressed life include health and wealth and money and relationships. So we're under that purview. So today I'm welcoming Alexandria Goff. She just goes by Ali, so that's how I know her. She's the founder and CEO of Goff Legal, which is a fast-growing California boutique law firm dedicated to estate planning and administration. She's passionate about building a values-driven practice, cultivating a strong team, and creating a client experience that's both personal and impactful. Ali regularly collaborates with nonprofits and professional organizations across the state, sharing insights on practice growth and leadership. In addition to leading her firm, she's a certified performance coach who supports fiduciaries and business owners in reaching their next level. Welcome to the show, Ali.
Thank you. I'm so excited to be here.
So I was introduced to Ali from a mutual friend or colleague that we both share that I met at a different retreat, who owns a large company who supports people actually that go through kind of the crisis that you help people prevent going through.
Yes.
And she referred me to you because I was looking for someone who was not very stuffy, but who could speak on trust and wills at our upcoming retreat, which is why we're interrupting June's Q&A months, because I just thought we're just going to pop this one right in the middle here. So today we're talking about estate planning, trust and wills, stuff that we think is boring, but Ali makes not so boring, as evidenced by, if you're listening, you can't see it, but her shirt says a future dead person. So she's got, we got to have some dry humor on this topic. And Ali, how did you end up having a boutique law firm that focused on trust and wills specifically?
Yeah, no, I am a little quirkier and very honest, it turns out. So that's where I live my life.
And we found out we were very kindred spirits when we got together. We're like, oh, I think we would like each other very well.
I think this is a good partnership. I'm very excited to be at your retreat, by the way. I'm really excited to meet these people and give them some really good information. But how I started this. So I graduated from law school. I was interested in estate planning. And I couldn't find a good fit for me. I wanted something very specific. I'm also, turns out, really opinionated and driven. And so I ended up, after searching for a job for many months. I think I tried a number of different places, did some contract work. And I was like, you know what? I'm going to start my own firm. I want to do estate planning in Placer County. That's my community. That's where I grew up. That's where my family is. And so I just opened my law firm and said, I do estate planning now. And the rest is history, although I've been doing it for 12 years. And it has evolved greatly from when I started it, but I got to do the thing I wanted, which was be in charge of my own life.
Yeah. Okay. So let's talk about, I think, something important. And before I met our mutual friend, I don't know if I understood the gravity of what happens when you die without a trust or a will. What happens in general? I think maybe we could talk about that, or we can start with a story, like something that we can start with anybody's story about like anyone that failed to plan this and why it turns out to be a very stressful and expensive mistake. That honestly, we'll just put this on the list of things we didn't know we needed to know. After, I would say there are some skills in life we don't know we need to develop, like changing your oil until you arrive there. And so today we're arriving at learning why this is a skill or a thing to develop. So however you want to open it, maybe these will feed together. What happens if you don't have an estate and will in place might actually serve us best first, or if you think the story will lend itself. We want both. So take it.
Yeah. And I think people may be a little confused about estate planning. They think a couple of things. One, it's for the rich, and two, it's for when I'm dead. The story that I bring actually is honestly really heartbreaking. It's this wonderful woman who'd been married to her husband for 40 years, or married for 30 and together for 40 or 50, like for a really long time. He was estranged from his kids and his sister and brother, because it turns out they were challenging. And he had a stroke and went into the hospital, and she called his family and said, he's not doing well. I want you to come check on him. And they showed up and caused all sorts of havoc. They were questioning all of her decisions. And the doctors were like, we're not listening to anyone. They didn't listen to his kids. They didn't listen to his wife. Anyways, we end up in conservatorship, which is what happens when someone doesn't plan and is incapacitated. It was so messy. She had to spend her money and his money to get control of her own husband, even though they've been married for 30, 40 years. And so it was one of those things where my family made a lot of money, but not like happy money. Not, oh, let's plan and let's like make sure our kids are taken care of. It was like, let's make sure she can put him in the most happy place for him and stop them from coming and visiting. They were coming and bugging him and yelling at him and like causing a ruckus with the care home. It was awful, awful. And so that's the number one thing is like, if this is not just when you're gone, right? This is also.
It could happen tomorrow, actually, for any of us. I remember when my mom was incapacitated in the hospital, and I don't remember how that all went down about some decision making. So I wonder if it varies from state to state. And I wonder, this word that you just used, I've never even heard of, conservatorship.
Conservatorship. Yeah. If you Google it in California, you'll find Britney Spears all over the place. And everyone's, oh, this is for like rich pop stars. And I was like, no. This is typically for people who don't have a healthcare directive or a power of attorney. It's designed to let someone make medical or financial decisions if someone's incapacitated. And none of us think we're going to be incapacitated. And yet people are living longer and longer. That's great. And I think a lot of my generation is now dealing with their parents not planning, going, I just need to pay their bills. We get phone calls all the time. Hi, my mom has dementia and I need to get a power of attorney. And we have to say, I'm so sorry. It's too late. If she doesn't know what's happening, she can't sign a legal document. Our conservatorship process starts at $10,000. Now, some of them are different, and every state is different, right? Every hospital is different. But HIPAA laws are more, this is the reason why a lot of this comes up, is because of HIPAA privacy. They keep getting sued for disclosing information. And if you don't have something that says you can get information about your own kid or your spouse, they might not give it to you.
Is that why with your client, this lovely woman who was married to her husband for 30 years, was it mostly a problem because there was like dissonance? And so the medical facility was like, to protect ourselves, we're just not going to tell anyone because there isn't a plan or a directive in place? Or do you think that like sometimes this slides every once in a while? I'm just trying to understand it, because it seems like crazy, right? Doesn't it feel a little wild that like the spouse of 30 years can't make a medical decision without this, what is it, health directive?
Yeah. And so in California, it's an advanced healthcare directive. Some states call it a durable power of attorney for healthcare. Living will, you'll hear that word too. A lot of states have very different, who makes medical decisions and what happens to my body after I'm gone, essentially is the document. So I get your question, like, yeah, maybe you don't need it because the family's not fighting. But it doesn't always work that way, and you don't know which way it's going to go. More challenging than medical, because medical is very like emotionally messy. Financial. If you are married, at least in California, and there's an asset that you have because you're in a relationship, but you just happen to not put your spouse's name on there and you're incapacitated, if they don't have legal documentation, no bank is letting them in. They have to get documentation, power of attorney, or a conservatorship. So there's no negotiating with banks. You might be able to sometimes negotiate with a healthcare provider, or maybe they signed a form a long time ago that happened to give authority. It's not all fighting. It's really just like access to information. And the more we know, the less and less banks, even with powers of attorney, people have challenges with banks.
I'm going to get more granular before I jump out then, because you were just talking about banks and things. And it reminds me of a story I heard about if you're a spouse and something happens to your spouse, and if you're a joint account versus there's other types of accounts, you still sometimes can't even access there's like things that happen, right, with the bank.
Sometimes they'll freeze the account if one of the account holders dies and you need a death certificate and those sorts of things. Yeah. So not only conservatorship, then we've got what happens if you die. We have other challenges, very state specific. Each state is very different. I'm based out of California. That's where my license is from. We have some of the most archaic and difficult probate laws in the country. Some states, not so bad, right? You just walk in and you fill out some paperwork and you could have access to documents. Here, it could take you 6 months or more just to get access to a decedent's accounts if they don't have a trust or beneficiary designations on those accounts.
Okay, so let's start right there, because that is what I learned from our mutual friend Maya, who owns a now nationwide company that helps people through this messy process. And just the fact that her company is nationwide says that pretty big problem. And it's
Everywhere.
Everyone's going to die. And so what happens when someone dies without a will or a trust? Do we even have a name for that?
Intestacy.
Oh, okay. We're not committing that to memory, whatever. Okay, so let's pretend someone doesn't have an official. And what makes it official? Do they can you just write it on a piece of paper, or do you have to do something else to make it really official? Technically,
I love this. I love laws. They're fun. They're interesting, and of course, lawyers are designed to dig through them and get around them and create new ones. That's what we do best. If you look up Aretha Franklin, you'll find when she passed, she had a bunch of handwritten notes all over the place that contradicted each other. And the one that they ended up admitting as her will was stuffed in her couch. She'd given all these different, someone who had millions of dollars, and millions of dollars went to the various lawyers to try and find this out, all because she'd handwritten it. So yeah, you can have a will handwritten. I knew a lawyer who probated a napkin before.
I was wondering.
A will, there's letters.
Not myself.
No, not best practice. So a will essentially, it's instructions. Here's where I want my stuff to go. Ideally, it is written with, you have executors listed and your beneficiaries listed, and you have it signed. In California, to be valid, it needs 2 witnesses, or it needs to be in your own handwriting. Every state has different requirements. So a will just gives instructions. Wills are great, but they don't avoid probate. And so the trust is the thing. If you don't want to be in court, if you don't like the court supervised process, the trust is usually the mechanism that keeps people out of the public eye and out of the public system.
We need to define probate, right? Because that we don't assume that anyone knows what probate is. So we're a health podcast, Ali.
Let's go
We're
back
stress
to
and health. Yeah. Probate's what happens if you don't have a trust. So what is probate? Trust. It's court.
Yeah, essentially, it is a court supervised process whereby someone collects the decedent's assets, pays their debts, and distributes the remaining stuff, whatever there is left, to the beneficiaries.
Yeah, some random person assigned by, or
it could
some
be,
state person.
Yeah, if you don't have instructions to the court, they're going to have to go down this line of who might be your beneficiary, and it may or may not be a family member that you like, or if you don't have any family members, technically we call it escheat. That's what that'd be. Anyways, to the state. That's pretty rare, but you're talking about stress, right? What is more stressful? Not knowing where stuff is supposed to go as a family member, not knowing the things they had, nothing's in place. Okay, how about every time you get on a plane, right? People get on planes and like, oh, I should probably have an estate plan. Well, if you had an estate plan, you wouldn't worry about it. When you got on the plane, you go, okay, I got everything dialed in. I don't need to worry about that particular thing on this particular adventure.
My brain's having a little bit of a playground in the background. If there isn't a trust and someone has to go through probate, that just means literally your parents' house, if they don't have a trust, it has to, someone else has to figure out and settle their estate more so than you. I'm thinking in my head, you shouldn't even be able to touch. Isn't that what happens? You can't even touch their stuff. Is that kind of?
Yeah, it's frozen.
Yeah.
Frozen.
Yeah, interesting.
Right? You can't sell a house unless you've got legal authority. And oftentimes it takes months to get legal authority. So someone's going to have to pay all the bills out of their own pocket or risk foreclosure. There's so much at stake when you leave it up to the court. Some counties
doesn't
are really small.
care about you, right?
Yeah. I don't care, I'll be dead. And I go, okay, fine, then don't get your plan done. And the next thing out of their mouth is, yeah, but I don't want to do that to my family. Awesome. Yeah. Here's some options. You can have a will, you can have a trust. Here's some options that you can, and they always pick something that actually makes their family's life easier. And also them sleep at night. That's what a lot of people get out of it, actually.
That was the conversation with the friend who reached out to me when I asked about will and trust. She said, I'm glad you're talking about this because this is the best gift you could give someone because it is such a nightmare if you do not have these things in place. So far, we covered that a will could, in theory, be written on a napkin. It could be written handwritten, but depending on the place you are, it might need to have 2 witnesses. So that's a will. Like, here's where I want my things to go. It might have executors and beneficiaries, but what is a trust? How is a trust different than a will?
Yeah. So first tip, go find a lawyer if you want to write a will, right? You might come with your wishes, but have someone actually make it enforceable in the state you're in.
So don't actually write it.
Don't write it on a napkin. That's not my advice. I'm not giving legal advice. We're just having a friendly chat today.
Yeah.
Trust. So a trust is like a contract, essentially. Someone creates a trust. They're the trust makers, trustors, settlors. They have trustees, or your managers. Those are the people who are in charge. And then we have beneficiaries. And so what's nice about a trust, the standard, we call them revocable trusts. They don't do much during your life, right? You're still in charge of your assets. You can buy stuff. You can sell stuff. You can put stuff in. You can take stuff out. It's really actually very flexible. It only really comes into play when you're incapacitated or you pass away, in which case that trustee, that manager role switches from you to someone competent, and they either pay your bills or you're dead. They will give it to your beneficiaries. And so it really becomes a very business entity, really, except for you don't have to deal with tax returns every year until you're gone.
Interesting. So a trust and a revocable trust are the same thing?
Oftentimes you'll find a revocable living trust, grantor trust, anything except for irrevocable trust. That's a whole different land in which we're probably not going to go into today. We're relating to tax planning, Medicaid planning, Medicare planning. There's all sorts of different types of trusts, but the type of trust that we need to avoid probate is like the most simple trust that gives you the most flexibility. You can change it when it's revocable. So you get a revocable trust, you go, I want to give it to my kids when I turn 30. And then your kids turn 30 and you go, no, I don't think that, no, not ready. I'm going to change it so they get it when they're 40. Wait, great. You can do that. Your kids won't know.
It feels like the same thing as a will.
Yes, it is, except for avoids probate.
Oh, okay. Got it. So if you have a will, you have to go through court. But if you have a trust, you do not have to go through court. And a trust is more out of an official document. Is that correct?
Yeah, it's a mechanism. It's a tool that we use to avoid the court process. Essentially, we're doing this because title companies need proof of who is the owner. And either you're going to go through the court system to prove it, or they've allowed this sort of trust mechanism to bypass that system. And it's private, right? People don't, sometimes the cost of probate is an issue. A lot of people don't understand that a probate is a public process. We publish in the newspaper your debts, your expenses, your family's addresses, by the way. Trusts, if no one's fighting, it's private. No one even knows, right?
Yeah.
Ideally, it just says, oh, the trustee sold this house to these people. And all the inner workings happen behind the scenes.
Interesting. Okay, one more question about trust, and then I'm curious about the cost of probate.
Yeah.
Because just this, when I look at like property and real estate property, sometimes people have things trustee of blah, blah, blah. And so is this just mean that they have their trust set up and so all of their properties and assets also have this kind of listed as such?
Yep. Generally speaking, yeah. If you see TR or trustee of the whatever so-and-so trust, they're in their representative capacity. So all of our real estate investors, yeah. Or it'll be an entity. That's another way to hold title.
Yeah. Okay, cool. All right. So I'm thinking about that probate. Is there like an average amount of time? I know it probably can be like quite broad, but isn't the minimum isn't it at least 6 months? But I'm sure it could be years. What's the amount of time that like usually people are stuck? I don't know if stuck is the right word, but go through probate.
Stuck is the right word.
Stuck is the right word. Okay, cool. How long are people usually stuck in this public process where everything is tied up? And how much money? I'm sure, again, you've seen like such a diverse, but I'm sure it only starts in the thousands, I would imagine.
Oh, yeah. Absolutely.
Like the minimum is thousands to go through probate. So in theory, if you're creating a trust, even though it may cost a little bit of money up front to validate and verify, you are only saving a crap ton by avoiding probate, or like your family is saving a crap ton by that. Is that correct?
Yeah. Average time period stuck in probate is 12 to 18 months.
Okay.
Now, that means from the time you filed to the time they distributed. Sometimes it takes another 3 to 6 to 9 months to get into court. So 2 years, depending.
Wow.
And don't forget, in a probate, nobody gets any money except for creditors and the courts and a bunch of referees, not even the lawyers, until the very, very end.
Yeah.
So not super great. Now, you can Google, at least in California, I think some states are You just pay the lawyer by the hour. Call the lawyer up and say, hi, my family member died. I'm nominated as executor, or I'm their only child. What does this look like? And they'll say, hand me some money. Here's what I'll do in exchange. Here's how long that takes. California is a special state. We have statutory fees, which means the state of California decides how much the lawyer gets paid.
Interesting.
Let's say I'm going to put in here, and let's just call it $1 million. And fun fact, at least here in California, the value is not your like the equity. It's the total value. So if you have a home, let's call it $1 million, and you have a mortgage of $750,000. The fees are based on $1 million. So I just ran a calculation. Yeah. Calculation for the attorney fee, $23,000. Calculation for the executor, another $23,000. Calculation of fees, probably another $3,000. So you're looking at about $50,000 for $1 million worth of assets in California.
Damn, isn't there like a documentary about the business of being dead or something like this? You're like, holy crap. Okay, so right out the gate, it gets passed on to the people who are alive, right? Like the people that you love or don't love.
If there's not enough cash, they're going to have to sell assets. So what if you have like a family home? If there's no one has enough money to write a check for $50,000 plus pay all the debts and expenses, funeral costs, mortgage, insurance, taxes, whatever needs to be paid off. If someone can't pay that, they're going to be selling that home. And that's some of the heartbreak that people don't think about. Or you'll just sell it, pay run off, and then everybody gets the chunk of change, which, I mean, better than nothing, but still it could have been done a lot better and a lot less stressful.
I know when we were talking before this, you said one of the biggest myths is that people think estate planning is for rich people, but you just pretty much demonstrated like, actually, you're going to spend so much money by not doing any estate planning is what you just essentially said.
And this calculation doesn't include that conservatorship process I talked about. God forbid you become incapacitated. You're looking at least depending on more, $25,000 in conservatorship fees before you even die. And then, of course, if you are under conservatorship, it's really hard to get a trust. So you're going to go through probate. So you're going to go through 2 court supervised processes, which they're just literally sucking the money out of all of your hard-earned money is going to the wrong people. I get so passionate about this because, yes, I make a lot of money when people don't plan. I don't like that money. I like the people who plan because I want to be able to look the family in the eye and go, your family gave you this gift. Let's fill out some paperwork. It's going to take a few months, but don't worry. We've got you. Here's the process. We're going to support you. And then we go, here you go. That's a better experience for everyone, including my team. They'd much rather plan and administer something easy than make more money on messy stuff. That's not fun.
Yeah, no
one's
happy money.
No one's happy.
Yeah. Okay. So we'll go to inheritance stuff next, but I just wanted, before we put a bow on trust and wills for the moment, is there a reason why having an online template might be a starting point, but why would that not be enough in this case? Because I think a trust is much more like official technically, but like why in general, what do you see going on here?
Yeah, unfortunately, when I review or my team reviews estate planning documents that they've created online, either they've selected the wrong forms. I've reviewed forms that are from the wrong state, so they therefore have the wrong language and are not going to be effective in the right state. They filled them out incorrectly. That's one of my favorites. I go, why do you have this? I didn't want that. I wanted this thing. Like, but you have this thing and you sign this and this is valid. And they're like, I didn't want that. But they don't sign it right. I had some clients, I swear you guys, with you, but your audience, I have clients that I sent them set of documents to sign, instructions. And this is from a lawyer. And I said, here's how you sign them. Do you know what they did? They signed them wrong. Thank goodness they have me, because we read those and said, oh, those are wrong. Come in, let's sign them correctly, because otherwise they would have been totally invalid. Not to mention there's no lawyer eyes on those things. Those online templates, they're not the worst, but I don't know that they're going to work. That's the problem. And
probably better than nothing, right?
Yeah. And the other thing that I maybe don't tell you is they don't work unless you put assets in them. You have a trust, right? Let's create a trust. The Ali Goff trust, dated June 14th, 2023. I created my trust that day, right? I have to put my house in the trust. We do that for clients. I have to put my bank account in the trust. I have to update my beneficiary designation.
Oh my gosh, it's like investing. It's like
you have to do
you
all
could open the
homework.
Account, but you have to actually put the thing. You actually have to turn it on.
Yeah.
To make
and a
it
lot
work.
of people who go, oh, look, I got this account. It was $349. I got my trust done. And we go, okay, what did you put in it? And they go, I don't know what you're talking about. I'm like, you paid money for nothing. It's not going to do anything for you. You have all these steps to do. And they were like, I didn't know that. And I'm like,
so glad you brought this up. I have no idea.
it's complicated. The reason why we have jobs, it's because it's complicated and we want to help people do it right. That is where the money savings is.
Yeah,
So,
for sure.
Yeah,
Super interesting. I know actually there's a lot to cover here for sure.
There's
right?
a lot here. Yeah.
Yeah. Okay. So let's talk about some inheritance things. This kind of got opened up a little bit before where maybe you want to hand something down. So what are some of the things that come into play when someone dies and there are gains or inheritance? And so some of the words that come up are capital gains, which is a term that's might not be appropriate here. I think it is a term used like with the sale of assets. So not even having to do with death, but it's like a very taxed process. I think that's always my concern is like, man, there's probably also, it's not just the cost of what you just shared before, but I think my concern is like death by tax as well with some of this. So let's just walk us through what happens with the inheritance process and some of the considerations around.
Yeah. So every state, so federally, there's an estate tax exemption, right? Everyone can give away about $13.99 million per person during their life and after their death and not pay taxes on it. Gold stars. Most of us don't have that much money.
People who inherit it?
Well, no, this is people giving it away, right? I sit here. If I have $15 million.
If you want to give me $15 million or 13.9, then you don't have to pay taxes on it. Okay, got it.
And neither do you.
Okay. Interesting.
Awesome?
That's way more than I thought. I thought it was like 40,000 or something like that.
Fun fact, every state has their own laws about how much the state death tax is or estate tax is. California, strangely enough, doesn't have one. Zero. You don't have to worry about estate tax here. Oregon, I think it's $1 million. That's when they start taxing you. Anything above $1 million that you give away during your life and after death. So you can't just be like, oh, I'm going to write a check right before I die. The IRS is like, oh, no, this is a lifetime gift. This is anything you've given away during life after death. And so each state has these very specific rules about how you give things away. One of the things that I think people miss, the capital gains, that is such a good question because we're digging into the tax code. If you give someone an asset during your life, let's say I give you stock that I bought for $5 and it's worth $500,000. If I give it to you during my life, you sell it, you have to pay capital gains with the basis of my $5 that I bought it for. But if I die and I give it to you either by will or trust or beneficiary account, right? It steps up basis to $500,000 and you pay $0 in capital gains when you sell it.
Interesting. So many little tweaky, little tiny things. Yeah.
Yeah. People do that with real estate all the time. They go, I'm going to avoid probate and I'm going to do that by adding my child's name to the deed of the house. I've solved all my problems. Sure. You saved a couple $1,000s from an estate plan. You have just cost your child hundreds of thousands of dollars in capital gains tax unknowingly.
Okay. I want to make sure I understand that. So let me summarize what I heard from you so far. Federally, people can give away $13.9 million in their life without tax coming or going. However, each state has their own little rider, which would be interesting for us all to go look up. And it would be a state tax, right? For our individual state. We would just be looking that up. And I'm trying to understand fully the capital gains with respect to death, because capital gains, how I perceive it or understand it, is the gains made from selling a property and then you're paying taxes on that. Normally, if we're not talking about death, right? So if you, I was like, I'm going to type it. I like to take notes. So I'm trying to type as you talk. I'm like, did I understand this? If you give someone an asset during your life and that person sells it, they have to pay capital gains. But if you get it via will, trust, etc., then there's zero tax on it. Is there a limit to that?
No. Now, remember, it's not that they never pay tax on it. It's that the basis resets on death. So let's say on my death, the stock was worth $500,000 and you inherited it. And then you sold it at $750. You would still have capital gains of $250, but you didn't have capital gains of $5 to $750. So it'll do this with married couples too in some states, depending on. So sometimes we wait for one spouse to die and then sell the asset because we reset the basis. This is why having professionals is so important.
Yeah.
CPA, financial advisor, estate planning attorney. Those online forms are not going to tell you any of this stuff. and you
Yeah.
could cause a lot more problems than you're solving by trying to save a few dollars.
And especially I think if any assets are involved, which I think probably everyone has some, not everyone, but many people have some assets of some sort. And so what you just also said that I don't fully get, but I'm thankful you said it, is if you add your child's name to a deed, you can accidentally cost them a lot of money. It's not the best way for them to save money on taxes.
Now, that fun fact, because Congress is fun, that 13.99 is set to expire at the end of 2025. And it might go down to, I think, 7 million per person. But Congress could choose to extend that law and it could stay up there. So this is one of those things that you have to be paying it. This is why you have advisors. They pay attention for you. But being a good educated human, you should be paying attention. If you're anywhere near there, you should be paying attention. What is that law? And asking your attorney.
So many things to pay attention to.
So many things to pay attention to. Yeah, that's why we send out letters and newsletters to our clients going, hi, this thing changed. If it affects you, you should come in.
Okay, crazy. Okay, feels like I was following bonus depreciation, but this feels like next level. Like we've decided to cut this in half. Big cut. Anyway, just interesting.
It can be. Yeah, especially we're talking farmland, property they bought a long time ago that's appreciated, Bay Area, any of the metropolitan areas that are growing really crazy. There could be a lot of value in there, but they're cash poor, right? It's not just like people who have millions of dollars in cash. Sometimes those are family like legacies we're talking about.
Right. I think that's like probably the really tricky part. Okay. So I think you just covered, I had a question about what should people know about capital gains tax when they inherit property, but if it's in a trust or will, you are at much of a tax advantage is how we can say it, I think. Right.
Yeah. I would say if you inherit assets, ideally, if you could know that in advance and plan for that, but if not, don't sell anything until you talk to an advisor. Hi, I inherited this thing. Sometimes you just need to get the basis so you can say, listen, IRS, this is what it was worth on death. This is what I sold it for versus, I don't know, I just sold it. And they're going to go, your loss, our gain.
Yeah, that's interesting. Yeah. I didn't even know step-up basis was a thing. I'm like learning new language. So glad we're getting together. So glad we're getting together in a few months so you could help me get us going on this whole process. Yeah. Okay. Anything else you want to say that comes up all the time around maybe minimizing inheritance taxes in advance? Or do you feel like we've covered some of the big ones right there?
Yeah, not really to taxes. I think those are the biggest things you need to know in terms of your own situation.
Yeah, cool. Okay. Let's talk about some things that you talked about earlier, which was living will, durable power of attorney, et cetera, et cetera. So we talked about wills that can be written on napkins, et cetera, but that's going to send you through probate. And we talked about the cost of that, whereas a trust is a much more fancy document version of a will that requires an attorney, essentially. This is interpretation. This is my understanding level so far. And then we've got this durable power of attorney, which can be different than the healthcare directives or whatnot. You use multiple terms. Okay, so let's talk about what's a durable power of attorney in general. Let's actually just redefine this because we may not have clearly. Yeah. And then what happens if we don't have one of those? Because we're almost making a checklist of documents we need to have. And a trust isn't necessarily a document, but it's like an account with your stuff in it. So it goes to the right place.
It needs a document. No, it's like this many documents. Okay, like a lot of pages, but
it's a small book. Got it. It's a whole binder.
Book. Yeah, it's the biggest.
A binder of things. Okay, but a durable power of attorney is a couple of pages, right?
Yeah, somewhere between 1 or 2 pages to could be 20 pages, depending on the complexity of the document. So there's 3 words that are important, but let's break them up. So power of attorney, right? That is the legal document that lets someone make decisions for you related to transaction. So anything but healthcare, real estate, bank accounts, investments, buying, selling, all that sort of fun stuff. And then the word durable, that indicates that it continues on after you're incapacitated. Because you can have a power of attorney. I could execute a power of attorney today that says, I want my spouse to be able to buy real estate. And he could go buy real estate today with a power of attorney. If I say durable, it's obviously in the document. If I become incapacitated, he can also use that document. But so everyone uses durable power of attorney because it means basically incapacity planning.
What are some of the wishes? So I know we were mixing this together because we were using an unfortunate event where someone was hospitalized and couldn't respond, make decisions for themselves, which I truly think can just happen to anyone at any moment. That's literally like that I'm speaking from my own experiences, obviously, where I saw this happen to my own mother. And so what are some of the wishes that might be in a durable power of attorney overall? Because I think earlier we were saying we were using this term a little bit interchangeably with a healthcare directive, but they could be separate or they could be under one. Is that possible?
They are separate. They're always separate. Yeah.
Okay.
You can have a durable power of attorney for healthcare and a durable power of attorney for finances. So in California, we just call them an advanced healthcare directive and a power of attorney for finance. But yeah, essentially one's, and they're usually not going to cross over. I don't think many states would have those crossover, usually because there's different governing sections of the law that said, okay, here's the healthcare law, here's the financial law. So let's pick apart maybe the healthcare directive a little bit. What might be found in there? Agents. Who are you going to make decisions when you can't? You're going to talk about sometimes end of life decisions. Maybe this is in your living will, might be in your power of attorney, but it says, if I'm in a coma, do I want to be left on life support? Do I want extraneous make measures to keep me alive or save my life? Or do you want to let's just let me go? Let's just not, we're not going to play that game. Sometimes it's disposition of your body, right? Burial, cremation. You can be turned into a diamond, turned into a tree, shot into space, sprinkled in the ocean.
Oh, I learned so many things
choices.
right there. I didn't have
so many choices. Organ donation. If you're passionate one way or the other about whether you'd like your organs to be used for science or to save someone's life, that would be in a healthcare directive as well. And the biggest challenge, and I think the thing that's really stressful, is if you don't have these in writing or you haven't explained this to someone, they have no idea what your wishes are. Do you really want your family guessing whether you want to be on life support or not, or if you want to be an organ donor? They have to make that decision for you. Either way, if you don't leave them with instructions.
Hinging back to the original story that kind of happened before you and I had a conversation where my friend and colleague reached out and shared her story with me, was a little side note she said was that her family now has like a digital copy of things readily accessible, because sometimes you create these documents and so no one even knows where the heck they are.
Yeah.
So you have some.
Oh, yeah.
So I'm sure you have some recommendations about how to store things and all those pieces as well, but not that we have to cover that, but I just bring that up here. Oh yeah, actually being able to access the document that helps give your directives isn't a bad idea in this day and age now. And I think probably on the positive side, like it's never been easier, in my opinion, to like access a document at any time. That's how I feel about it.
They have portals. You've got all sorts of like online servers. You got your computer, your thumb drives. Heck, you probably on your phone. I recommend people give a copy to their healthcare provider. So it goes in the whole system. So if anything happens, no one has to bring it. They'll just have it on file, but also bring it because you never know when you're going to need your piece of paper to shake around.
Okay. So we talked about wills and trusts, and then we're talking about the durable power of attorney and the other version for healthcare. Is there any other must-have documents that people need to work with someone to plan or create that should go on that overall checklist as they're starting to think about this?
Yeah, sometimes in the will, but sometimes separate. Guardianship nominations. Anyone with minor children has got to be writing down something and giving information to the court that if something happens to them, who's going to raise their kids? Maybe 1, 2, 3. I love 3's backup list. But making sure that we've got a list of who would care for your minor children, who's in charge of them, who's in charge of their money that would be inherited by them.
I really don't ever know if I want to ask this or get the answer to it, but what happens if you don't have that? What happens to kids? I suppose it depends on the state, but.
Yeah, essentially the court is going to decide based on the information they have at the time where they think the most appropriate place is. And it may or may not be what you wanted. Yeah. Chances are it's not going to be. Strange things happen when people die. Families show up from nowhere sometimes going, we had the best relationship and I know them and they told me. Crazy. So you really want to give as much information to the court because they're making a determination on where your kids will spend the rest of their adolescence.
Yeah, that's crazy. Okay. Any other documents, or you feel pretty good about that? Those are the ones you would start with. Essentially,
that's probably the biggest.
Yeah. Will, power of
trust.
Attorney.
Yeah. Will, power of attorney, healthcare directive, trust is a good one. And then, guardianship. There's some other like ancillary documents. Those will be state specific in terms of how we fund those trusts. But those are the biggest, the most important ones.
Okay. All right. So what age, life stage is the right time to get serious about this kinds of stuff? And I grouped this under, when we had a conversation about what you would bring to the retreat, I was thinking about this in terms of like asset protection overall. And we talked about, okay, plan A is if you're going to live your ideal life till 90 and then things are going to happen the way you want. And then the plan B is, and if things go south or if you get incapacitated, that's a thing. But anyway, what age or life stage is, I don't know. I feel like this is a very subjective question, but when do you see people getting serious about, or what is your feedback around this?
Yeah. I think the majority of our clients come to us in retirement-ish age. I call them the golden years. They've gathered some wealth. They've probably seen some loss. They're starting to think about their own mortality a little more and are ready to get serious about it. I don't know that's the ideal time though, because like you said, that's great if you're just going to like live to 90 and then die in your sleep, which we all hope to, right? Maybe 100. I don't know what everyone's goals are. But that doesn't account for what you said, the plan B. And the next sort of chunk of clients that come to us are those who have minor children. They're now going, oh, I have created a human that I love so much. And I have assets now. And I know that I want them to be well cared for if I'm not here. And that's when you start having kids and going, oh, you have life insurance, you probably have a house, you might have some retirement accounts. And the thing about that we didn't really go over, if something happens to the parents, two parents, it doesn't happen that often, but it does happen, unfortunately. When it happens to both parents with no planning, all of it goes through probate. You're like, that was pretty bad. It gets worse because then it goes through a guardianship and it's stuck in the courts with them being supervised until they turn 18. And the second that kid turns 18, they do a final accounting and boom, they get 100% of the money in their account. Can you imagine what an 18-year-old is going to do with a bunch of money?
I can only make guesses.
Yeah. And so we've got like double. And so I think anyone who has minor children really, you don't need a crazy fancy plan, right? Let's just talk about making sure that we avoid probate in the event of something happening to either or both parents. If there's only one parent, even more important. Check it, pay attention to it, and then maybe do some more sophisticated planning once you get in those other ages. Most people don't need sophisticated planning in their 20s or 30s or even 40s, but they need something.
Yeah, you can start with something. So I was talking to our finance expert this morning for the retreat, and she said something that I think applies completely to this area of conversation as well. She said, one of the biggest problems I see is that women don't take action around something or don't do something because they don't know everything yet, or they don't have all the pieces. And actually, I think I see that in health too sometimes. But in general, I feel like they're really married here, not only because we were talking about investing stuff, and this is kind of set protection overall big pictures things, but I think it would be very easy because I think I might be that person as well. It's like, oh, I hadn't really thought about where I wanted that stuff to go because I hadn't even thought about that at all. So I wouldn't take action if I didn't know everything yet. Where it's we suddenly think that like when we're 60, we're just going to know where we want everything to go. Exactly. So I just think it's, we have to start somewhere. And that's actually leads to my next question. So it's if someone's listening to this or they're a little overwhelmed by the idea of it, what is your advice for starting?
Yeah, listening to this is great. Maybe doing some self-education. A lot of attorneys will have a specific attorney, get a referral, see if they have a webinar or a seminar where you can learn from the expert. Online can be a wild and crazy place. Sure. Also has so much misinformation and a lot of crazy town on there. But finding really good reputable sources, doing some education, but I would actually meet with a professional who can say, okay, based on your situation, here's what I would recommend. Or here are your options. You can't, as I said to I was presenting to a group of teachers, wonderful humans. And I said, you can't learn this. You can't learn yourself into an estate plan. Sign up so we can help you. And they laughed and they went, okay, fine. And they signed up and we got their estate plan done finally because they've been trying to figure it out for years. And I was like, you can't learn anymore. You've done it. But if you're just starting out, I think I have a YouTube page. It's very California specific. But like I said, find a referral for someone that you like in your area. See if they have some educational information on there. And then don't wait until, most people go, I don't know who my guardians are, so I'm not going to plan anything. I was like, yeah, but now nothing's planned. That's not a good solution either.
Yeah. For me, I think about like before we get together, and I understand it more from the attorney. I'm just waiting for this retreat to unlock this next piece for me so I can take the next pieces. But what I think about even from hearing this conversation is literally just taking pen to paper and what do I think are some of the answers to some of these questions? Do I have any opinions about my organs? Do I have any opinions about who should take care of me when I'm sick? By the way, it's my sister-in-law, 100%. Thank you, Helen. And
but in writing.
Right. Yeah. Just those little pieces. And I only say that just because man, it is from the health. Oh, let me share a little something. If you don't have something that kind of sucks about healthcare right now is that if you don't have someone who has some healthcare background, sometimes you can get walked all over. And you probably have this in your industry as well. It's like, it would be very easy to get walked over if you don't know. And so my experience has been time and time again that these people with a health background are able to really advocate for their family. And it's like both of my parents would be like completely incapacitated. My mom would be dead if it wasn't for like the healthcare providers in my family advocating for her 100%. And my dad would be paralyzed if they wasn't. And
You're right.
yeah, it is unfortunate. And it's not meant to be fearful based, but that's why I say my sister-in-law, who's like a lovely nurse and human who has saved both of my parents' lives. Thank you very much for that by just being a very good advocate, right? And so I only say that because I can also choose my husband somewhere in the lines as well, but he doesn't really have a health background at all. I would be a great person for him to put down because I will be a good advocate for him. But sometimes you don't know. People. It's not just, oh, I love him, so I'm going to choose him. I'm going to choose someone who's got some know-how in the background on purpose. I suppose you want to ask that person as well, usually.
It's a good idea to check in with them and go, hey, I'm considering this, but that's why you do backups, right?
Yeah.
But if she's not around, you want a backup, you want a third. And most online forms aren't going to say that. The lawyer will go, did you know you could have 3 people in a row? And you're like, okay, I only have 2. Fine.
Yeah.
Let's do 2. You can come and update these later. Give it 5 years. You'll change your mind anyway. That's fine.
Yeah.
But at least you'll have that protection for that time period.
I feel inspired from our conversations just to put some pen to paper so that way I can because I'm sure the right attorney will give you a list of here's the things you're going to need to fill in to start.
Yeah. I can give you some, in 2 minutes, the basics that you need to decide. So first, who would make financial decisions for you if you couldn't? Name 3 names. Second, medical decisions. Who's going to make medical decisions for you if you can't make those? 3 names. Medical decisions. Do you want your life prolonged or not? Do you want to be an organ donor or not? What do you want to have happen to your body? On the what happens to my stuff? So who's going to be in charge? That's you're going to make financial decisions. Where's your stuff go? If they're not around, what's your backup? If you have minor children, who's going to raise them? Who's going to watch their money? And at what age do we give control of the money over to the kids? That's like some of the biggest decisions you have to make. If you have even half of those made, usually a really good advisor can help you fill in the bubbles or fill in the blanks of the other things. Okay, you don't have that. Oh, you don't have a trustee? I have a professional. Oh, you don't know what prolonged life means? Let me walk you through the options. Let's play some scenarios and you can make a decision. Usually we can get the thing to the end if you come with even half of those made.
Yeah, that's really great. I love that so much. And Ali, where can people find you online? I know you said your YouTube channel was a little bit California specific, but I still think it's a starting point.
It's got good information. Yeah. So Goff Legal, G-O-F as in Frank, F as in Frank, legal.com is our website. I think if you just Google Goff Legal YouTube, you'll find it. I'm sure there's a link on my website there. We've got social medias that nobody pays attention to.
It's fun stuff. It just translates real easily and single slide information, right?
Yeah. We get most of our clients from referrals and return clients. So although we have a presence and I do a lot of educating, most people come to us who already know us, partially because it's a sensitive topic and they want someone they can trust. Even as lawyers, there's some shady people out there, or they don't do only estate planning. We only do this. We don't do personal injury. We don't do criminal law. I'm not going to divorce you. Dead people, future dead people. That's not what I do.
I feel like that shirt lands better after the whole conversation too. So.
It does. You're like, oh, that makes more sense. Why she's so dark.
I'm not even sure if I should listen to this actually, right? At the beginning.
Oh, she knows what she's talking about. And if they're in California, they're welcome to fill out a thing. If they're not in California and you find my website and go, well, I like you. I know a ton of attorneys. I'm happy to connect you if I can. I'm happy to do that. So I think in the show notes, you have some sort of website they can click on and go, I heard her on a podcast. I live in this state. Please help. And we're not going to charge you anything to say we can't find you a good attorney in your state.
Yeah. Lovely. If you want to come hang out with Ali and I, there's probably also a link in the show notes to apply for the retreat, which is very well curated of cool humans. And we're going to have a great
There's only
can't wait to talk about
a few spots left, right?
That is true.
Get
so
that
do it now.
Available.
Exactly. I'm so glad to have met you. Thank you. Shout out to our mutual friend, Maya, for this introduction. And I hope that people found this helpful today, and I can't wait for it to come out. So thank you so much for coming on today.
Thank you.
just keep breaking.